This lecture will discuss Section 5 of the Voting Rights Act. In many respects, this is a history lesson because Section 5 of the Voting Rights Act is no longer operational because of the Supreme Court's decision in Shelby County versus Holder. But many of the issues that came up under litigation over Section 5 of the Voting Rights Act remain relevant today. These cases also deal with fundamental questions of race and representation, as well as ultimately congressional power to protect minority voting rights. And so it's important for us to, I think, still study these Section 5 cases, as well as Shelby County versus Holder itself, to understand some of the contemporary relevance of congressional efforts to protect voting rights. So let me give a very quick background to Section 5 of the Voting Rights Act. And this is really sort of does injustice to it, but just to give the bare facts as to the origins of Section 5 of the Voting Rights Act. In the 1960s, as Congress was considering civil rights legislation, particularly in the wake of Bloody Sunday, where civil rights protesters marched across the Edmund Pettus Bridge, President Johnson said he wanted the toughest damn Voting Rights Act that Congress could pass. And at the time, it was extremely difficult for civil rights plaintiffs to prevail in court in a way that could have lasting impact. So that you'd have groups like the NAACP Legal Defense Fund going in and knocking down a literacy test as being racially discriminatory. And then the next day, the jurisdiction would pass a grandfather clause or a poll tax or some other good character test. And so each one of these victories turned out to be Pyrrhic. I mean, it would be very difficult to win these cases anyway, both in the lower court, then on appeal, sometimes at the Supreme Court. But then the southern jurisdictions would end up passing other kinds of tests or devices in order to defeat the wins that the civil rights plaintiffs had garnered. And throughout the 1960s, like through most of the history of Jim Crow, there were tiny percentages of African Americans who registered to vote or held office in the South. And so there are several key provisions of the Voting Rights Act that were passed at the time. Section 2 we've dealt with in another lecture, was later amended in the 1980s, which prevents voting laws with discriminatory effects. Section 4 is the provision that was overturned by Shelby County versus Holder, which required certain covered jurisdictions to get federal permission before implementing any new voting laws. And we'll talk a lot about that with the so-called pre-clearance regime. There are other provisions, though, of the Voting Rights Act that remain operational today. Sections 3 and 8 give the federal courts and the Attorney General authority to certify counties for assignment of federal observers for elections. Section 201 bans literacy tests and some other tests and devices. Section 203, passed later, specifically deals with language minorities and requires ballots and other materials in other languages in areas with populations that are 5% or more speakers of languages other than English. And Section 208 allows for voting assistance for anyone who's unable to read. But we'll focus today on sections 4 and 5. Usually when people neglect to sort of talk about section 4, which is what we call the coverage formula, and focus on section 5, which was really the enforcement mechanism. And so when I say section 5, I usually mean 4 and 5 together. And so here are the components of section 4 and 5. First, there was a coverage formula. This is a unique law that applied to certain areas of the country, but not others. Mostly in the South, but not exclusively in the South, as we'll see. The second is that if you were a covered jurisdiction, then you had to pre-clear any voting laws with either the Department of Justice or with the U.S. District Court for the District of Columbia. And those bodies would then determine that it would not grant pre-clearance if these laws retrogressed, meaning that they made minorities worse off. And so you'd have many different types of suits that could be brought under these relevant provisions of the Voting Rights Act. If a jurisdiction just decided to pass a law related to voting, sometimes you'd go into your local district court, a plaintiff would, to prevent a covered jurisdiction from implementing a non-pre-cleared voting change. Sometimes a jurisdiction would go into court in the District of Columbia to get preclearance for its voting change. So there are those two avenues. Almost 99% or so of the changes to voting were submitted to the Department of Justice for preclearance, but sometimes a jurisdiction would go into the U.S. District Court for the District of Columbia to get permission for its voting law. And then there are a few other kinds of cases, for example, where under the Voting Rights Act, some of these jurisdictions that were covered, if they could show that they had not been discriminating or violating Voting Rights Act for the previous decade, they could launch what was called a bailout lawsuit to get out from under the strictures of Section 5 of the Voting Rights Act, and that would be also a lawsuit brought in the U.S. District Court for the District of Columbia. These lawsuits were brought in, and the statute mandates that they be brought in the U.S. District Court for the District of Columbia because there was concern about potential regional bias if you had to bring them in your local district court. Finally, a very rarely used part of the law was actually what we call bail-in lawsuits, where a local district court would then subject a new jurisdiction to preclearance because of its violation of voting rights. But let's talk about the Section 4 coverage formula, which is eventually struck down in Shelby County versus Holder. So the coverage formula was reverse engineered to get at most of the southern jurisdictions that were of concern when it came to voting rights violations. The original trigger in Section 4 of the Voting Rights Act went along the following, which it said that if this jurisdiction employed a test or device, such as a literacy test, and had voter turnout below 50% in the 1964 election, later amended to apply to the 68 and 72 elections, then it was covered under the Voting Rights Act. It said also if you had voter registration below 50% would be, or voter turnout below 50%, but if you had voter turnout below 50%, that would usually capture all these jurisdictions. So there's two elements to it. First, does it have a test or device, and does it have low voter turnout in those elections? This is not a coverage formula that focuses on intentional racial discrimination, right? It doesn't look at whether there have been lawsuits, where there's evidence of low black turnout even. It's just aggregate voter turnout below 50% and evidence of the use of a test or device. That definition of test or device was expanded to include any jurisdictions with more than 5% non-English speaking population, but had ballot materials only in English. Those are the 1975 amendments. But again, it's the presence of a test or device plus low voter turnout, not, for example, a whole history of voting discrimination lawsuits. But this coverage formula was an attempt to try to get at many of the southern jurisdictions that had a history of violating voting rights. And so here you can see the map of the areas covered by Section 5 of the Voting Rights Act. You'll see that most of it includes the South, but it doesn't include all of the South, and it includes some places outside the South. For example, it includes some of the boroughs of New York City, includes Manhattan, Brooklyn, the Bronx. It doesn't include all of Florida, just a few counties in Florida. It includes parts of California. Because of the language minority provisions, it includes Alaska, and it includes Arizona, but it doesn't include New Mexico. It includes some areas with large Native American populations in South Dakota, but it also includes a few townships in New Hampshire and Michigan. And so that's because these were places that had a test or device and had low voter turnout. It's not about the intent of what may have caused that low voter turnout. It's just the mere presence. It's an automatic test. So if a jurisdiction was covered under Section 5 of the Voting Rights Act, it had to pre-clear any practice or procedure with respect to voting, regardless of its potential to discriminate. So even if a voting law was making it easier to vote, any change had to be pre-cleared with the Department of Justice or the U.S. District Court for the District of Columbia. And as I said before, that meant that you would, usually you just file sort of paperwork with the Attorney General, and almost all of those changes were pre-cleared. The ones where the DOJ or the district court would be skeptical or would take a much closer look would be redistricting plans, voter ID laws, similar things like that. But most, if every polling place move had to be pre-cleared with the Department of Justice, every sort of minor change in the laws, and usually that would be rubber stamped and allowed to be pre-cleared. But sometimes, if there was concern that there was racial discrimination afoot, then they would be denied pre-clearance. But the redistricting area was the area where we saw a lot of action when it came to pre-clearance. So, what was the standard for granting pre-clearance, either at the district court level or the Department of Justice? Before the 2006 amendments to the Voting Rights Act, the standard was neither that the law cannot have the purpose nor will have the effect of denying or bridging the right to vote on account of race or color. This meant that it couldn't have, as the court interpreted it in 2000, a retrogressive purpose or a retrogressive effect. So what does it mean to say retrogressive? Retrogression is a term of art, meaning that the redistricting plan or voting law is intended or has the effect of making minorities worse off than they are under the kind of previous status quo, what we call the benchmark. It's not about just discrimination in the same way that it would be under Section 2. So intentional discrimination is not enough. It's that you have to have retrogressive purpose or retrogressive effect, actually making minorities worse off. That was changed in 2006, but the 2006 law, of course, was struck down in Shelby County versus Holder to make clear that any discriminatory purpose would be grounds for pre-clearance denial. And then the court said that the law can't diminish the ability, or the statute said that a redistricting plan or a voting law can't diminish the ability of any citizens on account of race or color to elect their preferred candidate of choice. But the basic rule throughout most of the history of Section 5 of the Voting Rights Act was that you cannot retrogress. The law cannot make minorities worse off. It's not about discrimination against some ideal standard of racial equality. It's about whether the law changes the status quo so as to make minorities worse off. So how do you assess retrogression in the redistricting context? Because people disagree as to what types of districting plans make minorities worse off. For example, are minorities worse off with control in a few districts or influence over many districts? How do you measure control or influence? Because sometimes a group may want to sort of spread their population across many districts as opposed to over-concentrating them into too few. So our majority minority districts, that is, districts that are over 50% minority, are they special, such as that if you eliminate them, if a jurisdiction eliminates them, that necessarily is retrogressive? Or should a more flexible standard apply, which focuses on the performance of a district, for instance, whether it succeeds in electing a minority preferred candidate? So there are many cases that deal with this question. Two I want to just point to in particular: Beer versus United States and Georgia versus Ashcroft. In Beer versus United States, the court upholds a plan that increases the number of majority-minority districts, even if it doesn't maximize. And Beer is what gives us the notion of retrogression, that Section 5 is not about preventing all forms of discrimination. It's just about preventing backsliding, preventing retrogression, preventing minorities from being worse off. And so in that case, since the number of majority-minority districts was kept constant or increased, it was seen as perfectly legal under Section 5 of the Voting Rights Act. In Georgia versus Ashcroft, though, the court really grapples with these questions as to what does it mean to represent minorities? What does it mean to make them worse off in the redistricting process? And Georgia versus Ashcroft upheld a redistricting plan that actually reduced the minority percentages in certain majority-minority districts. And it adopted an expansive interpretation of the Voting Rights Act to allow for trade-offs between control and influence districts, meaning that there was nothing special about majority-minority districts under Section 5, that you could reduce the number of majority-minority districts and increase the number of influence districts and still comply with Section 5 of the Voting Rights Act and its retrogression requirement. And so it was thought that Georgia versus Ashcroft would lead to the deconstruction of many of these majority-minority districts. And that's why in the 2006 amendments to the Voting Rights Act, the reauthorization, they tried to overturn Georgia versus Ashcroft, but then they ran into the problems of Shelby County versus Holder and striking down Section 5 and Section 4 of the Voting Rights Act. So now let's move to the constitutionality of Section 5. The court upheld Section 5 and Section 4 of the Voting Rights Act multiple times between 1966 and 2013. And the standard of review that was applied in South Carolina versus Katzenbach was very deferential. So in 1966, the court applied the standard of review from McCulloch versus Maryland, which was basically a kind of rationality review standard where the ends were legitimate and any means that were rationally related to those ends were seen as within congressional power. And so while the trigger, the coverage formula of Section 4 did not include all of the jurisdictions of concern and maybe included some that weren't of concern when it came to violations of Voting Rights Act and racial discrimination with respect to voting rights, it was good enough for the Supreme Court because it was not trying to, it didn't require Congress to be surgical in identifying particular jurisdictions and being perfect as to which ones were the bad actors and which ones were the good actors. The trigger, the coverage formula was good enough in terms of capturing most of the South that was had a history of violating voting rights, and it was seen as passing that standard of review. In 2006, the Congress reauthorized the coverage formula that had existed for the previous 25 years or so. And it overturned Georgia versus Ashcroft to establish the standard that focused on ability to elect. But the key issue in Shelby County versus Holder was whether the coverage formula that had existed since the 1960s could still be upheld by the Supreme Court in 2006. And so in Shelby County versus Holder, which eventually reached the court in 2013, the 5-justice majority strikes down Section 4 as exceeding congressional power to enforce the 15th Amendment. It finds the coverage formula inadequately supported by the record that Congress developed in the 2006 reauthorization because the same kinds of evidence that had existed in the 1960s didn't exist in the 2000s. And whereas Congress in the 1960s pointed to the extensive violations of African-American voting rights and the lack of office holding by racial minorities, those same statistics were not available for the 2006 reauthorization, that things had changed. And so if the same kinds of statistics as in terms of voting rights and office holding were not didn't designate these jurisdictions as particular areas of concern, the court found Section 4 of the Voting Rights Act to be unconstitutional. And if you look between the 1960s and the 2000s, it is definitely the case that many of those barriers that prevented African Americans in particular, but Latinos also from voting, were removed, and there was great increases in voting and office holding by racial minorities over that period. And so the evidence that was brought to bear in 2006 was not of that kind of character, that there were these huge racial gaps in turnout, although there were, particularly in off-year elections, significant racial gaps in turnout, nothing comparable to what we saw in the 1960s. But the court in Shelby County versus Holder finds that the current burdens of the Voting Rights Act are not matched by current needs, such that Section 4 is not rationally or logically or sufficiently related to preventing the present-day challenges to minority voting rights. In effect, what the court was saying is that Congress has to reevaluate the coverage formula. It has to go through and not merely adopt what had been on the books for the previous several decades, but that it has to sort of identify which jurisdictions have been committing voting rights violations and then adopt a trigger or coverage formula based on that. Now, whatever happened to that kind of lower standard of review that was applied by the court in South Carolina versus Katzenbach based off of McCulloch versus Maryland? And the court seems to apply what it seems like a higher standard of review, although it doesn't say that it's doing so. But the basic argument is that current burdens need to match current needs, and that the failure to do so sort of discriminates against certain states. In fact, the court comes up with, from a sort of other case law, this notion that the selective treatment of these states by this old coverage formula violates the notion of equal sovereignty of states. So Justice Ginsburg dissents from the 5-justice majority in Shelby County versus Holder. She thinks that the Reauthorized Voting Rights Act does pass the McCulloch-style rationality review from South Carolina versus Katzenbach. And she makes the point that when you reauthorize statutes like this, they should be presumptively constitutional, not only because the initial record justified the legislation, but it's the deterrent effect of the statute itself which prevents the creation of the record that the court wants in this case. So, for example, she says that what the court is doing here, it's like saying that you need to take, because you're not getting wet in a thunderstorm, that therefore you should take away the umbrella. And so her point is that the reason that you don't see these gaps in turnout or office holding is because Section 5 of the Voting Rights Act has been working. And so we shouldn't apply the same rule to a reauthorization of a statute that we do to the original passage of it. And she finds that the 15,000-page record in the case, in the legislative record, was sufficient to maintain the coverage, that there's a history of denials of preclearance, that there's a history of deterrence through what's known as more information requests, and that if you look at Section 2 litigation, that there's good evidence to suggest that it was, justifies the coverage formula. So whereas the majority focused it on turnout, the dissent focuses on a lot of these second-generation barriers, such as race-based vote dilution. And she feels that the availability of bail-out and bail-in with respect to the Voting Rights Act makes it a more targeted preclearance or coverage formula, so that jurisdictions can get out from under the strictures of the Voting Rights Act, and some could be bailed in depending on whether they continue to discriminate with respect to the right to vote. So here's where we are, which is that the coverage formula of Section 4 is struck down by Shelby County versus Holder. This whole notion of preclearance as to whether you can force jurisdictions to get preclearance from the federal government, the court certainly upheld that in South Carolina versus Katzenbach and other cases. But whether the current court would be willing to uphold it, well, that's an issue for another day, and that day does not seem to be close at hand, because Congress doesn't seem able to come together to reauthorize a new Voting Rights Act, although there are proposals on the table like the John Lewis Voting Rights Act that would do so. So as a consequence, covered jurisdictions no longer need to submit changes in voting to the Department of Justice or the Voting Rights Act. And so we'll see whether the logic of Shelby County, in that it sort of constrains Congress's power to enforce the 15th Amendment, to what extent will that be applied to other sections of the Voting Rights Act, such as Section 2 of the Voting Rights Act, which prevents race-based vote dilution?